Dear viewers, welcome to yet another episode on course of property law. I am Dr. Shivani Verma from Law Center 1, Faculty of Law, University of Delhi. Today we are going to discuss concept and evolution of property. Let's start with introduction. Property, possession, and belongingness are not the new terms. These concepts have been existing in the society since the time human beings started to gather and live together and civilization started. It was long back that the men started realizing and valuing the concept of having valuables in his control and name. The meaning of the power was also derived from the concept of asserting claim over things and people too. Property in most common way is used to describe as proprietorship over the objects. It can also be described as a thing which a human being can have an ownership upon. It included living as well as non-living things. Throughout the world, property is given various meanings, but one thing which is universally applied to the concept of property is it is what belongs to a person and what he wants his descendants to carry forward and inherit. Property in the widest possible sense includes rights of a person. If we give property a restricted meaning, then it would include only the proprietary rights of a person and not other legal rights. These property rights institute the status of personal condition of a person. Another interpretation and meaning of property only those kinds of rights which are both proprietary as well as real. The law of property is a specific field of law that deals with proprietary rights in rem. That is, it is a right against all. Now, let's understand evolution of the concept of property. In the words of Frederick Bastiat, life, liberty and property do not exist because men have made laws. On the contrary, it was the fact that life, liberty and property existed beforehand that caused men to make laws in the first place. So man started claiming property as his right because each of the man wanted an asset in his own person on which nobody else had a right to but he himself. A man is said to have a right to his property, he may be equally said to have a property in his right. But because of the civilization that man had to transform it in such a way that he could not live a life in deprivation of the property. In the words of Martin Luther King Jr., property is intended to serve life, and no matter how much we surround it with the rights and respect it has no personal being. It is part of the earth man walk on, and it is not man. In words of Blackstone, the inferior hath no kind of property in the company, as the superior is held to have those of the inferior. According to Locke, free man has a property in his person. Every individual has the right to preserve his property, that is, his wife, liberty, and estate. However, Austin believed that it is the context that alters the meaning of property. Property can have different meanings at different point of time and in different contexts. Property can signify the right of enjoyment in one context which will exclude servitudes, but sometimes it can also include servitudes when it comes to enjoyment of easement rights. In contemporary scenario, the intellectual and intangible property has also been included in the meaning of property as copyrights, patents and trademarks, etc., which are considered to be intellectual property rights and are considered to be the part of the concept of property. There are many schools of thoughts explaining the evolution of the concept of property. Natural theory, Grotius, Locke, Blackstone and Pufendorf are a few who stood by the natural theory. In natural theory, the concept of property is based on a simple principle of natural reason, which in turn is derived from the very nature of the things. According to Grotius, all the things originally were without an owner, and then whoever captured them or occupied them became their owners. John Locke proposes in his theory of property rights, which is rooted in laws of nature, that the law permits the individuals to appropriate, acquire, and then exercise control and rights over things in the world like land or other kind of material resources. Pufendorf asserts that initially everything belonged to everyone, and it was people's world as a whole. Nothing belonged to one and everything belonged to everyone. It was later that demarcation started to happen as to what belonged to whom. The labor theory, as given by John Locke, is basically about approbation, ownership, and creating entitlement over the property. It is an extension of the natural theory. In Lockean concept of property, naturally, as per as the Bible, God created land and resources for all. Now, the one who exerts labor upon these natural resources performs an act of original appropriation and hence gains the permanent ownership above it. He also, through his theory, justifies the legitimacy of the private rights over the property. He says, every man has a property in his own person. He has right to preserve his property, that is, his life, liberty, and estate. However, jurists like Bentham and Henry Mene differed in their approach and held that law responsible for establishment of the concept of property. They believed that it was not who occupied what that established the title. Possession and initial occupancy were the reason to claim, which was for the law to substantiate the real title. Leske criticized the labor theory and said that there are other ways to appropriate property like will and inheritance, so calling labor the only mean to appropriate and assert the ownership on the property is somehow only half of the understanding. Second theory in this regard is positive theory. Positive theory was propounded by English jurist Herbert Spencer. Spencer argues in his work that right to property contradicts the law of equal freedoms. It is essential part of human nature and existence that they are given the right to property. The idea that desire to acquire, hold, enjoy, and dispose of the property is the core character and nature of all human sounds contrary to the communist theory. Spencer in Social Statics further says, if a propensity of personal acquisition be really a component of man's constitution, then that cannot be a right form of society which affords it no scope. It is also true that no change in the state of society will alter its nature and its office. To whatever extent moderated, it must still be a desire for personal acquisition. Whence it follows that a system affording opportunity for its exercise must ever be retained, which means that the system of private property must be retained. And this presupposes a right of private property. For by the right we mean that which harmonizes with the human constitution and divinely ordained. The theory was in perfect synchronization with the utilitarianism of Bentham. The theory was defended on the ground that right to property is useful to the society. And until this right is not overridden by the higher and larger public needs, it has to be protected and prevailed. Spencer argued that if Adam Smith had the rightly argued that the society which safeguards the property of its people grows and prospers because propensity to hold, barter and exchange is the inherent nature of all human beings, then Any such attempt that is contrary and suppressing such natural urges will always remain unsuccessful. Spencer, in his words, believes that society must understand the human constitution and to harmonize with it must work upon establishing the rights over things which are property or property like to create a sync with this human constitution. Spencer, however, was criticized by Wiltshire due to inconsistency and variation in his conclusion. His ideas of land nationalization and reform kept on changing, and so did the idea of the role of the government in context of property and ownerships. Positivism based on rights and moral sense always leaves multiple choices of interpretation and misleads the idea of property. Next theory in this context is metaphysical theory. Kant and Hegel propounded metaphysical theory. In the context of property, Kant never believed that property rights were the creation of the government. He said that property will exist in form of private property, including rights over such properties irrespective of the fact that societies are with or without government and established law. As Kant claimed, a civil constitution only provides the juridical condition under which each person's property is secured and guaranteed to him, but it does not actually stipulate and determine what that property shall be. Kant explains the concept of property as an attachment. He asserts that a thing will be called a rightfully mine thing if I am so deeply connected to it that if anyone uses it without my consent, he causes me an injury. Hegel says property is the objective manifestation of the personality of an individual. In other words, property is an object on which person has the liberty to direct his will. He finds the idea of property to be the reason at first that creates a bond and gives satisfaction through building an idea of belongingness towards a property. There is an actual physical relationship between the processor and the object, and this bond is considered to be personal will as the most important concept of property. The theory was labeled to be too much based on theoretical assumption and less grounded on the real facts. Now, the next theory is historical theory. Historical theory propounds that private property has slow but steady growth. Bentham and Henry Maine were considered to be the supporters of this theory. Roscoe Pound gave an understanding that it was the collective ownership, that is, it were the group of people who jointly held the property, like the tribes living together and appropriating and holding the properties under them. Then, in stages, the concept of private ownership over the property grew. Firstly, it was natural independent possession without any interference by any, including law and state, and then came juristic possession and finally the concept of absolute ownership. Bentham and Maine also believed that man and families did not own the properties initially. It was the larger society under patriarchal setup that held the property collectively, and it was quite later that single individuals started asserting upon the ownerships of the property. However, the idea of having ownership without any possible interference by law and state was not accepted very widely. Next theory in this regard is psychological theory. Bentham says property and law are born together and die together. He believed that there is no reality in the concept of natural property, and property is an idea that is created entirely by the law. Property is the basis of expectation because it is humane to expect a benefit from the property that one possesses. More than a concrete right, it is the relationship that a man shares over a property that creates his rights over it. There is no form or color or visible traces to express this relationship, and that is why it is right to say that it is not physics but metaphysics that might address and create the concept of property. Bentham further says the idea of property consists in an established expectation, in persuasion of power to derive advantage from the object according to the nature of the case. However, Bentham also attributes this psychological expectation to be the work of law. It is law that guarantees me and leads me to the expectations, and it must be only the law to ask me to reckon it to. Bentham postulates the property to be the concept of mind and belonging to the metaphysics, which is most of the times criticized for being too indefinite and less concrete or realistic. Next theory in this regard is sociological theory. This theory is also called as functional theory, and it considers that property is kind of social interest that promotes security of a person's honor, privacy and reputation, etc., which can only be realized through the right to have access onto the property. The jurists like Diggett, Karl Marx and Lasky were supporters of this idea. Sociological understanding of the property is derived from the idea that property should not be interpreted in terms of right that are private, but in terms of social function. Property can be understood as an institution which ensures that maximum of the interest and wants are satisfied. The sociological theory was propounded by Lasky, Jenks and Karl Marx. According to the sociological theory, property should not be considered in terms of private rights, but should be considered in terms of social functions. Property is an institution which secures a maximum of interest and satisfies the maximum of wants. Property by these jurists is considered to be a varying aspect that holds the capability of further change. Lasky says that like any other fact, property is also a social fact and very prone to alter, while Jenks says property is a right that should be made in harmony with equity and good reason. Any absolute unrestricted right to use or to misuse the property must not be granted to any individual. The social relevance of the right to property must be looked after. The property should be owned in confirmation of the welfare of the society. The theory, the way it is explained by Roscoe Pound, is based on the idea of reputation, which can be upheld through the excess over the property. As pointed out by Roscoe Pound, interests of personality like the security of one's privacy, honor, reputation, etc., can be realized only through the access to property. Any property which is unjustly acquired is sin against all. Sociological school establishes the concept of property as an ownership over the assets based on mutual respect, trust, collective growth and enrichment. Concept of property. In the most comprehensive sense, word property includes legal rights of all the persons except his personal rights, which constitute his personal condition or his status. Article 17 of the Universal Declaration of Human Rights also declares that right to property is everyone's right individually as well as in association, and nobody can be deprived of his property arbitrarily. In the matter of Chairman IV Pradhikaran versus Puri Industrial Coke and Chemicals Limited, it was held that property and rights over it are sacred and inviolable. No one can be deprived of them unless and until there is a public necessity which is legally ascertained and a fair, just and advance indemnity has not been paid. Property can be divided into many kinds, some of which are corporeal and incorporeal. So, first is corporeal property. Corporeal property is also called as tangible property because of its perceptible and real existence. It mostly relates to the things that are materials. Also, the ownership rights over such material things are permanent, general, as well as inheritable for the users. Corporeal property can further be divided into two subcategories, movable and immovable. Any property which is not immovable will fall into the category of movable. It includes all the movable goods like gold, clothes, chattel, etc. On the other hand, the property which is not movable will be termed as immovable property. This will include land, things that are permanently attached to land, and benefits arising out of the land, etc. Second kind of property is incorporeal property. Incorporeal property, which is also known as intangible property. It is mostly used in the context of intellectual or non-conventional property. This property includes all those interests which are valuable and are also protected by law. Recently, these properties are recognized and law has also created a vast mechanism to protect them. The scope of this property is widening day by day, and virtual property is also being included in it. The incorporeal property can further be divided into two subcategories. First one is rights in re propria and rights in aliena. While right in re propria is used in the context of those non-materialistic things which are produced by human skills, expertise or labor like goodwills and trademarks, etc., right in aliena is used in context of encumbrances in form of right in rem over the property which is owned by someone else, like in case of easement and lease, etc. The courts, through various judgments, have tried to decode the concept of property. In one such matter of R.C. Cooper versus Union of India, the court observed that in today's world, the conventional understanding of property is required to be expanded. And instead of corporeal only, the concept must include incorporeal property as part of it, like in the cases of copyrights and trademarks, etc. In another case of V. Tulsamma versus Sisha Reddy, the court held that ownership over a property can be established by various means, and will is also a legitimate mean to do so. In India, right to property was initially the fundamental right which was guaranteed under Article 31 of the Constitution, but after 44th Constitutional Amendment in 1978, it was omitted and a new article, that is Article 300A, was inserted in the Constitution. The amendment changed the nature of the right to property, and from fundamental right, its ambit was basically restricted to a right of a person to hold a property. But no one can be deprived of this right except by the authority of law. Supreme Court clearly dismissed a PIL in case of Good Governance India Foundation versus Union of India, seeking to make right of property again a fundamental right. It was already in the matter of I.R. Kolo versus State of Tamil Nadu that a 3-member bench declared the right of property as a mere constitutional right and not a fundamental right. Hence, the concept of property existed in one form or the other since the time of human existence, but it definitely changed its meaning and objective as the world and the law evolved. Property as a concept will always have a scope to progress and change, but in a civilized society, property will always encompass the facets of ownership, reputation, and relevance in social contexts. So that is all about evolution and concept of property. Thank you so much.